Major breaking news out of the United States Supreme Court today. The Second Amendment Foundation has just filed a powerful brief arguing that it's time for the United States Supreme Court to take another Second Amendment case, specifically answering the question of whether or not the Second Amendment protects young adults in America. The answer, of course, is yes, it does. But the big question is, will the U.S. Supreme Court grant cert? Let's break it down when we come right back. Hey folks, I'm Mark Smith, host of the Four Boxes Down, a proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and I'm proud to say the top voice of the Second Amendment in America. Thank you, 2025 Gundies Awards. All right, before we break down this huge brief submitted in the West Virginia Citizens Defense League case involving the Second Amendment Foundation in the U.S. Supreme Court, I want to give you guys a heads up. We have a very, very big event coming up that you're going to really enjoy in just a couple of days at the end of this week in celebration of Halloween. That's right. There's something I've done that's going to make you all very happy, I suspect. And I'm just giving you a heads up. You're going to be watching for the announcement in just a couple of days. I think it's going to be on Friday afternoon, but we will see. Little heads up. Pay attention, folks. Okay. Now, with that said, I'm happy to report that in the U.S. Supreme Court, the Second Amendment Foundation, in the case of West Virginia Citizens Defense League versus the ATF, has just filed a reply brief arguing why the U.S. Supreme Court should grant cert in this case. Just to jog your memory, in this particular case, out of the United States Court of Appeals for the Fourth Circuit, which is out of the state of Virginia, in Richmond, basically this is a legal challenge that was brought arguing that the federal law that prohibits 18, 19, and 20-year-olds from being able to buy from federal firearms licensees handguns is unconstitutional under the Second Amendment. And that is clearly the right answer. But as you may recall, as we sit here today, the United States Supreme Court has already granted cert, which means they've already agreed to hear on the merits, 2 Second Amendment cases. The first case is the Wolford case out of Hawaii, out of the Ninth Circuit, asking the question of whether or not Hawaii's default law that says you cannot carry your handgun in public into a public accommodation, into a place that's open to the public but privately owned. You're not allowed, even with a concealed carry permit, mind you, you're not allowed to bring your concealed carry firearm with you into that private location that's open to the public. That's gas stations, that's restaurants, that's convenience stores, that's rest areas, whatever it happens to be, under that that no carry default rule, sometimes referred to as the vampire rule, because vampires cannot get into your home without first and foremost being invited, according to the mythology. So that's the Wolford case. The Supreme Court agreed to hear that case. But the Supreme Court also agreed to hear the pot case involving whether or not under 18 U.S.C. 922 G3, whether or not possessing marijuana or really being a regular user and or addicted to marijuana while possessing a firearm is constitutional or not under the Second Amendment. Is that law constitutional? That is the case of Hamani. So because the Supreme Court has already granted cert in 2 Second Amendment cases, the Hamani case dealing with a criminal case, and of course the Wolford case dealing with Hawaii, basically, the Department of Justice under Donald Trump and Pam Bondi, but this specifically, let's point the finger where it needs to be pointed, and that is the Solicitor General John Sauer. I'm sure this was his decision. The Solicitor General John Sauer, who represents the Trump administration from the Supreme Court, who's overall done a very, very good job. He's done a very good job winning lots and lots of cases, especially on the emergency docket for Donald Trump and the Trump administration. That's huge. Great job. But the Solicitor General's office here, which is part of the Department of Justice, is specifically saying to the Supreme Court, don't grant cert in this case. Specifically, they're not saying that the government should win this case. What they're saying in this brief, this is what the government is saying at least, is that you already have going to hear 2 Second Amendment cases, Supreme Court. You're going to hear the Wolford case. You're going to hear the Hamani case. There's no need for another Second Amendment case to be heard this term. Decide those cases of Wolford and Hamani, and then after you've done that, send back for further consideration, presumably, this case of West Virginia Citizens Defense League for further consideration in light of those decisions that we're going to get from the Supreme Court in the next many months. Well, the Second Amendment Foundation was not having any of that, and they filed a reply brief opposing the government's argument, saying that, yes, we, the Second Amendment Foundation, think that the U.S. Supreme Court should grant cert in this case of West Virginia Citizens Defense League as well, for many reasons. And frankly, the Supreme Court probably should grant cert in this West Virginia Citizens Defense League case, dealing with the question of whether or not 18, 19, and 20-year-olds have full-blown Second Amendment rights. And it's quite interesting that the reply brief here on behalf of the Second Amendment Foundation does a very nice job outlining five separate reasons based upon what the Department of Justice has literally argued in court, 5 separate reasons why the Supreme Court should indeed grant cert in this case involving young adults and the Second Amendment, involving, of course, the implication of that federal gun control law. This is 18, 19, and 20-year-olds cannot buy handguns from FFLs. That's a federal law, mind you, not a state law. Here's what the reply brief starts off with in a very powerful way. In its brief response to the petition for cert, the government, that's the federal government, concedes that the courts of appeals are squarely divided over the question of whether 18 to 20-year-old Americans have rights protected by the Second Amendment. It acknowledges that this case is an appropriate vehicle through which to address this important issue, as it poses no risk of mootness, given that the Second Amendment petitioner here is an association with thousands of members, which has successfully identified members with standing throughout the course of this litigation and will continue to do so as long as necessary to maintain a live controversy, and declines to defend the decision below on the merits. Well, that's very powerful stuff, because what essentially it's saying is that the United States government is not saying to the Supreme Court, don't take the case because, frankly, young adults have no Second Amendment rights. Instead, they're just saying, don't take the case now because you already have taken a couple cases. So there's no need to take a third case. But I have to say the Second Amendment Foundation did a very nice job rebutting that point as well. In addition to what they already said, they also make these points. The federal government does not expressly oppose this court's review or seek denial of the writ, but rather asks this Supreme Court instead to hold the case over pending the resolution of 2 other Second Amendment cases in which this court has granted cert already. The federal government could hardly do otherwise, given that this case presents a square conflict over the constitutionality of a federal statute, and as the federal government rightly explained in its petition for the review in Hamani, when a lower court has invalidated a federal statute, the Supreme Court's usual approach is to grant cert. And that's powerful stuff there, because keep in mind, the Hamani case dealing with whether or not federal gun control law 18 U.S.C. 922 G3, dealing with if you are a regular user or addicted to marijuana and you possess a handgun or you possess a firearm, does that violate that federal statute? And if so, does that in turn, is that consistent with the Second Amendment, or is that federal statute as applied to Mr. Hamani have to be struck down? Likewise, at Wolford, the Ninth Circuit said with respect to Hawaii that law was constitutional, but with respect to California, it was not. And again, there's been other courts in the Wolford context that have ruled in favor. The Ninth Circuit ruled in favor of the vampire rule, saying it was constitutional under the Second Amendment, but several other courts, including the U.S. Court of Appeals for the Second Circuit out of New York City, said that the default rule dealing with no carry default is unconstitutional. So both in the pot and gun context, as well as the no fault, or I should say the no carry default rule, in both contexts, you have a circuit split among federal district court judges and federal courts of appeals judges coming out in different directions. So too is that the case with whether or not 18, 19, and 20-year-olds have full-blown Second Amendment rights. Some federal courts of appeals have said, yes, they do, and other courts say, no, they don't. So you have a clear circuit split over a federal statute. And where you have a circuit split over a federal statute, usually the Supreme Court wants to take that case and resolve it. And they want to resolve it for several reasons. One of which is if you have a national law, a federal law that applies to all Americans, you want to make sure that the law is interpreted one way, in a singular way, uniformly, as applied to all the country. That is not what you have today. Right now, in the Fifth Circuit Court of Appeals, which is Mississippi, which is Texas, which is Louisiana, those are 3 big states, folks. A lot of people there, a lot of Americans there. In those 3 big states, this particular federal gun control statute that says 18, 19, and 20-year-olds cannot acquire handguns from FFLs, that is not being enforced down in those states because the Department of Justice says we're not going to force those. We're not going to force that statute because the U.S. Court of Appeals for the Fifth Circuit says it's unconstitutional. In contrast, if you're an 18, 19, and 20-year-old in other parts of the country, that law is still being enforced. So you've got some Americans who are living under one legal regime, and then other Americans are living under another legal regime, even though we're dealing with a single nationwide federal statute that's supposed to apply to all Americans equally and uniformly. And that is not what's happening here. And again, as the reply brief by the Second Amendment Foundation points out, this uniformity, which should be the law of the land, is not happening. And that is another major reason, if not the most important reason, for the U.S. Supreme Court to grant cert and resolve this question once and for all. Is this particular federal law that says 18, 19, and 20-year-olds cannot buy handguns from FFLs, is that constitutional under the Second Amendment, or is it not? Here's what the Second Amendment Foundation had to say about it. Since the filing of the petition in this case, the need for review has become more stark as the federal government has made clear that consistent with the executive branch's ordinary practice of intra-circuit acquiescence, it does not plan to enforce the same laws challenged here within the geographical boundary of the Fifth Circuit, i.e. the states of Texas, Louisiana, and Mississippi. The validity of a federal law, uniformity in the decisions of the courts of appeals on important constitutional issues, and uniformity in the enforcement of federal statutes are among the most important reasons this court, i.e. the Supreme Court, exercises its jurisdiction, and all three factors are present here in this case of West Virginia Citizens Defense League versus ATF. And that's exactly right. As a matter of institutionalism, as a matter of what the Supreme Court has historically done, which is to clarify and resolve circuit splits where different parts of the country and courts in different parts of the country have a clear disagreement about how a particular case should come out, that is why the Supreme Court steps in to resolve that circuit split. Here you have clear circuit splits over whether or not 18, 19, and 20-year-olds have full-blown Second Amendment rights. Some courts say they do. Other courts say they don't. Now, there's one other critical factor here, which I think is a very powerful point made by the Second Amendment Foundation here. It's very savvy they made this point. Think about this for a moment. The federal government is saying to the Supreme Court, put this case on a shelf, let the court decide the Wolford case, let the Supreme Court decide the Hamani case, and then at the end of June, when your term is over, send back the West Virginia Citizens Defense League case to the lower courts and let them reconsider it. Okay? In some hypothetical world, that might make sense. But here's the point that was very astute to make, and that is this. Think about what we're dealing with here. We're dealing with 18, 19, and 20-year-old individuals who want to be able to buy a handgun from an FFL right now. They only have 3 years, right, to benefit or knock out this law and have their rights respected. Once they turn 21, this federal law is no longer going to matter to them because they'll be 21. They will have aged out. So what the Second Amendment Foundation is arguing here is that even though theoretically in the world of the Second Amendment jurisprudence, you could delay this case for a year or two, and maybe it doesn't matter. But what it really, really, really does matter is for these individual young adults right here and right now that have been in court fighting, trying to get their rights respected under the Second Amendment before they turn 21. Because once they turn 21, they turn into a pumpkin. This case becomes moot as to them, and they will have basically had their Second Amendment rights violated for their years they were 18, the year they were 19, the year they were 20 years of age. And that's why in this brief they said this is not a situation where you can take a case and put it on a shelf and then deal with it down the road. Because while this case is on a shelf, these individuals are suffering constitutional deprivations every day by being denied the ability to acquire handguns from FFLs because The lower courts are not doing what they're supposed to do. They're not respecting the Second Amendment. And therefore, that is another reason why the United States Supreme Court, in this case of West Virginia Citizens Defense League, should step up, grant cert, and take this case. And I should just add one additional point, which is also made in this brief, which is this. It is not unusual in other constitutional contexts, First Amendment cases, 14th Amendment cases, equal protection law cases, doesn't matter, for the U.S. Supreme Court in a single term to take multiple cases involving some aspect of law, like 3 cases involving the First Amendment, 3 cases involving the search and seizure requirements under the Fourth Amendment, the Due Process Clause of the Fifth Amendment or the 14th Amendment, doesn't matter. There are many instances where the court has taken multiple cases involving those other constitutional provisions in a single term. So therefore, there's no reason for the Supreme Court not to take 3 or even 4 Second Amendment related cases in a given term, which is what basically the Second Amendment Foundation is arguing for them to do right here and right now. As to what happens, it's hard to say. I could see this going either way, but I'm certainly hoping the Supreme Court grants cert in this case and resolve that young adult question, which I do think we will win. All right, folks, so there you have it. Hope you enjoyed today's episode here at the Four Boxes Diner. Make sure you subscribe at Four Boxes Diner over there on X. And don't forget to both subscribe on YouTube and to Rumble. And I look forward to talking to all of you again real soon here at the Four Boxes Diner.
Orders up. Table 2A.